Calder.
Mr Speaker, thank you for the opportunity to take another call on the Policing Storage of Youth Identifying Particulars Amendment Bill. I take cognizance of my colleague Rahui Kartanei's impassioned comments about unemployment among particularly young Maori and offending among young Maori, and it is a huge concern for this government. And I would draw to her attention that there are thousands more youth guarantee places in trades academies on stream to help address that problem, of course, as well as growing our economy. This, however, is not the time. I think this particular bill that we're considering now is not really, that argument is not apposite to this debate, because what we have here, as has been pointed out by a variety of speakers, is an unintended consequence of a drafting of a bill which has led to the police having removed from their ability to use certain tools. And these tools are identifying particulars of offenders. When the Policing Act in 2008 was passed, it was assumed that the legal situation relating to the police's ability to keep these identifying particulars, fingerprints and photographs would be carried over from the Police Act 1958. The simple matter was that it wasn't, and there was no policy decision made to change this. It was, as we know, an unintended consequence of the drafting of the bill, and we've heard many reasons why from people who were in the House at the time. So I think it's a very simple situation we're dealing with here. I acknowledge the concerns of my colleague, but I will say no more at this stage, Mr Speaker, other than to commend the bill to the House.
Call Chris Hipkins.
Thank you very much, Mr Speaker. Mr Speaker, I think it's really important that we keep into perspective what we're doing here. We're correcting a mistake that was never intended. We're restoring the status quo. So we're not actually making significant change, we're restoring the status quo. And I think it's really important that we keep in mind that this mistake, this change that has occurred to the policing legislation inadvertently was never debated by the public, was never debated by Parliament. People didn't have the opportunity to make submissions on it at a select committee. It was never intended. So to say that we're somehow erring by restoring the status quo and repealing this unintended change to the law is simply wrong. This is the right thing to do. Restoring the status quo in the absence of debate that should have preceded the change is the right thing to do. I'm not saying that we shouldn't have a debate about whether, in fact, the police should store the identifying details of young people. I personally, if we had that debate, would stand up in Parliament and say that yes, that I support the provisions that are in the current legislation around that, but I'm not afraid of debating it. But I don't think we should debate it in the context of a mistake that was made and in the context of correcting a mistake that was made. And basically, the arguments being put forward by the Green Party and the Māori Party seem to be that we should leave in place a law that was unintended, that was never debated, and I don't think that that's right. I'm not entirely sure what the point of Rahui Kartanei's many contributions so far have been, unless, of course, she wanted to devote 20 minutes to demonstrating quite clearly that the Māori Party have absolutely no influence over the national government, but we didn't need 20 minutes for that, we knew that anyway. And so I think that all she's managed to do so far is demonstrate the fact that I don't seem to have any influence over the national government. The Green Party and the Māori Party, I think, have both missed the critical point here, which is that the bill is restoring the status quo. It is not designed to make a significant law change. And I think, as I mentioned in my first reading speech, which I'm delivering my second reading speech only shortly after delivering the first reading speech, Moana Maki didn't hear the first one, so I'm sure she'll appreciate it. I think it's really important that we continue to respect the role of the youth court. The youth court is there to protect young people from themselves in some instances, as the Minister mentioned, but also from the harsher edges of the adult criminal justice system, the sharp edges of the criminal justice system. We could use that Bill English phrase of the sharp edges. The youth court is designed to protect young people from that. I think that's good. I think many of the concerns that Dave Clendon raised, I had some sympathy with many of the concerns he raised, but some of the concerns he raised to me, taken to their logical conclusion, questioned the valid role of the youth court. And I actually think the youth court is really, really important, and we shouldn't be questioning the role of the youth court, and whether in fact the youth court is doing a good job. I think the youth court does do a very good job. And I'm really disappointed if this debate, correcting a mistake, is used to question the validity of the youth court. The other thing that I'd be disappointed by is if this debate's used to question the police, because I spent 10 years fighting with the police, a legal case with the police, which ultimately was found in my favour, but I'm not holding a grudge against them on that, because I think overwhelmingly, I'm a very forgiving member, but overwhelmingly the police do a very, very good job. And look, I'll tell you what the other thing is. I went out on night patrol with the police a few weeks ago. It was a real eye-opener for me. First opportunity, what was that? First opportunity, I was there voluntarily, I can assure the Minister, and it was an eye-opener, and a lot of the people that they were dealing with on a Friday night were young people. And, they are young people who were intoxicated, or they had been taking drugs. They were very difficult to deal with, and overwhelmingly what I saw was police acting in a very responsible manner in their dealings with young people. They were not going over the top. They were basically looking after the young people who were getting themselves into trouble. And I think we should respect that really important role that police play in that. I don't think that we should always assume that the police are out to get people and that, they're not. They're out there ultimately to protect everybody, and sometimes they're protecting young people from themselves. And I think they do a pretty good job overall of that. And I want to thank the police, the Hutt Valley Police, for giving me the opportunity to go out on the night patrol with them. They've obviously forgiven me for the 10-year battle as well. They probably don't remember me either. Well, thank you, Steve Chadwick. That was very flattering. So coming back to the reason. Well, I'm happy to go into the case in detail if it would be useful for the Minister, but coming back to the substance of this particular bill and the reason why we want to pass it under urgency, as I mentioned in my first reading speech, I don't want to see young people who have been through the youth court, who have effectively been found guilty of doing whatever they were doing and who have been dealt with under the Child, Youth and Family Act through the youth court. I don't want to then see them being let off on the basis that the information that the police stored that identified them in the first place had been held by the police illegitimately. The other thing, of course, is it might not necessarily be the dealings of the youth court that are brought into question, but a subsequent proceeding in the district court could be brought into question on the basis that the information the police used in that district court hearing, which had been collected for an earlier hearing by the youth court, that could also be questioned, and I don't think that that's a right thing to do. Or if it is the right thing to do, it should be done deliberately by Parliament and not by mistake. It was never done deliberately by Parliament. It was done accidentally. And if the Green Party and the Māori Party had very strong views on this during the debates on the Policing Act, they could have raised those at the time. And as my colleague Leanne Dalziel pointed out, the only two people to speak on that part of the debate were Chester Burrows and Annette King. The Māori Party and the Green Party didn't feel sufficiently strongly about it when this mistake occurred to even debate that part of the bill at all. So all of these concerns that they're raising now, if they are legitimate concerns, there are opportunities for them to raise it, but not in the context of preserving an inadvertent law change, which is what opposition to this bill does. It preserves a law change that was not intended, that was not debated, that was not scrutinised, that the public never had a chance to have a say on, and I think that's the wrong thing to do. I think Parliament is doing the right thing by correcting the law back to the status quo, and then if there is a legitimate debate to be had about whether the status quo should be changed, there's a way to do that, and the way to do that is obviously to introduce a bill and then to put it to select committee and then let the public have their say on it. We shouldn't be making law changes by accident and then arguing that they should be preserved. And I think that's what this bill is all about. It's all about making sure that the will of Parliament is actually respected, even when a mistake is made, and that's what happened in this particular case. So with that, Mr. Speaker, I'll end here and look forward to the committee stage of this debate.
Melissa Lee.
Thank you, Mr. Speaker. It's a pleasure to rise.